Good evening and welcome once again to Plain Talk Election Special. It's a pleasure being with you. This is the second edition of Election Special. It's been another very fast moving week with lots of developments, but of which I will select just two for some discussion. The first is that the announcement earlier today, Wednesday, that Dr. Berry Ramsaran, Minister of Health, has been relieved of his post 9 days after what President Ramatar described as verbal outbursts and insults hurled at a women's rights activist. It is instructive that the Guyana release did not say that his employment was terminated. Dr. Ramsaran remains on the list for the PPPC for the upcoming elections. As you know, we have a list system in which a vote for the list is a vote for each person on that list. With Dr. Ramsaran remaining on the list, would anyone, having heard the President's description and his colleagues' description of Dr. Ramsaran's attack on Ms. Najir, still want to vote for that list? Now, my take on it is if President Ramatar is truly serious, and this is not expediency, then he needs to ensure that Dr. Ramsaran get off the list. There are mechanisms. He should be asked to resign from the list. I should point out as well, and this is a reminder to the President, that so far he has failed to follow up on the tape conversation which Attorney General Anil Nandlall had with the Kaicho News reporter. The President had indicated that he was getting the tape validated, even though Mr. Nandlall had said that the voice was his. So we wait to see what happens, both with respect to Dr. Ramsaran and Minister and the Attorney General Anil Nandlall. The second issue I want to raise this evening is a contract signed by Dr. Roger Luncheon with a relatively unknown outfit, and this contract concerns a program that began in 2009 and is described as an e-governance ICT program. The total project cost for that program, the entire ICT program, was listed in the estimates at 13,167 million, that is 13.167 billion. Because the project was so badly mismanaged by the President's son, the entire project was suspended. The next thing we knew was that a contract surfaced, signed by Dr. Luncheon, handing over the fiber optic cables, the repeater stations, and all the equipment from Letem to Castellani House. And bear in mind, Castellani House is where our National Spy Center is. This project, this entire arrangement, and the use of those assets will last for 40 years, whilst the person, Mr. Mohammed, will get tax holidays and other concessions on his operation, on the operations using government's assets. Now, embarrassed at the revelation, Dr. Luncheon has attacked the media in a press briefing earlier today, describing the reports as nonsense, crap, and scandals. Now, all one has got to do is to look at that agreement. One has got to look at the estimates. Dr. Luncheon, in my view, has again lied about this in terms of what he said the project, in what the expenditure has in fact been. It is considerably more than that, and I would suggest to Dr. Luncheon that he reviews the estimates of the year. Now, this leads me straight into my first guest, Mr. Ronald Burch-Smith, President of the Guyana Bar Association, and I had given him a copy of the contract to have a look at. It's signed by Dr. Luncheon, it's signed by the other party, and I would ask him, as a practicing lawyer of some years, what he thinks of the standard, just the preparations and the presentation and the manner in which this contract or this agreement has been drawn up. Ronald, welcome to Plano.
Hi, Chris. Thank you. I'm happy to be here. Chris, I should point out that it's considered poor form unnecessarily to speculate about the quality of work of one attorney. Assuming that the document you showed me is intended to be a legal agreement and was prepared by an attorney. I mean, an agreement can be written anywhere in any format once certain things are present: offer, acceptance, an intention to create legal relations, two parties with the proper legal authority to enter into a contract. What I've noticed on the agreement is that it refers to DAX Constructing Services Limited. Limited identifies a company that was incorporated before the current Companies Act came into agreement, so it would be prior to 1995.
That's correct.
I'm not sure that the entity was in its existence then.
This was incorporated in 2010, in fact.
Okay. I mean, there's always room in contracts for a few errors here and there of that nature. But I'm sure if the document was prepared by an attorney, there are a few things that the attorney would have addressed his or her mind to. One example is obviously the mechanism by which DAX Contracting will obtain a license to engage in telecommunications business. I'm not sure that the signatory to the agreement has the authority to issue a license. No doubt he does have the authority to bind the promises of the government.
For 40 years?
Well, he obviously thought so. It remains to be seen. I think that the agreement generally appears to be something that is done, it's a bit rushed, because apart from the telecommunications licensing, there's obviously other nuts and bolts that need to be properly identified. There are a few strange promises in the agreement, so I'm not sure this was intended for public consumption. It may merely been intended to be a promise between friends of some sort.
Given the sums of money that one hears are involved, would you have expected a higher standard of preparation?
I don't know, Chris. I mean, rich people are entitled to do as they please with their money.
You mean Dr. Luncheon? I'm concerned about what the government is what the state of Guyana is being committed to by Dr. Luncheon.
Well, Chris, what I can say is that as a citizen of Guyana, given the sums of money you suggested are involved in the project, $5, $6, $8, $10 billion, one would have expected a bit more light on being shined on the government's intentions. So, for example, it's laid clear to the public, well, this is the situation, these are the problems we've identified. We would like to identify an entity to assist us in managing and operating the connections to let them. We've been unable to do it. These would be the terms of the agreement. With interested parties wish to bid for it, these would be the terms on which they bid. This is what they can expect. And then you sort through a number of offers, in a fairly transparent manner. I know you haven't drawn an issue of procurement, but this is the sort of service that if the government wanted to procure, that would have fallen under the purview of the Procurement Commission, that could be aired and ventilated in a proper manner. The difficulty with doing things of this nature, of this importance, on the eve of an election, quietly, without public scrutiny, is that it gives it an air of impropriety, which is most unfortunate where public funds are concerned.
Let's move on. You have been president of the Guyana Bar Association for the past 2 years, but you've been observing issues as they have arisen. I want you to talk about two of the underlying principles of our Constitution: constitutional democracy and rule of law. Take them in whichever order.
Thank you, Chris. The issue of the rule of law, the term is used frequently. I'm not sure that it's really properly understood by many of those who use it. I mean, there are several conceptualizations. Rule of law essentially is the idea that persons and institutions that exercise power, particularly public power, should do so in a manner that's constrained by a codified system of rules or laws. Now, there's the thin conceptualization, meaning that once there's a law, it's passed by Parliament, it's published, it applies prospectively and not retroactively, and it fits certain very general ideas like certainty and that sort of thing, equality, that's sufficient. You have the rule of law. By that measure, slavery fell within, the proper framework of the rule of law. Nazi Germany was, of course, governed by laws, and many of the things they did were lawful. So that's the thin idea, which obviously leaves much to be desired. There's the thick notion, which deals with a lot more than the formalities, which goes into the substance, about fairness and that sort of thing. And then there's a much more substantive view that goes with issues of justice, deeper issues of equality. Are laws right? Are they fair? And that sort of thing. In Guyana, obviously, you have a regularly constituted parliament. Well, sometimes, depending on what rights the president wants to exercise.
Regular but not frequent, perhaps.
Regular but not frequent. I mean, we've had almost a year without parliament. And I think given that for the first time the parliamentary debate actually meant something in this 10th parliament, I think parliament took on even greater importance, and not having it obviously had greater consequences. It's quite unfortunate that parties in parliament could not find a way to work together. I mean, I know that blame for this is generally attributed to the president's reticence. But speaking for myself, of course, I think that there are things that the opposition could have given ground on some issues. I have my own views about the issue of public procurement commission, the no objection. If it was indeed the sole issue that the government wanted to establish, it was being able to maintain that no objection. I haven't been convinced by the arguments about why that no objection should be taken away. I'm sure there are good reasons for it. I just haven't heard, and personally I'm not sure I agree with them. But getting back to the second issue of constitutional democracy, there's much concern that in our current structure the Constitution is being ignored and abused. You have commissions that should be established under the Constitution that are not being established. For instance, the Integrity Commission, the Same Procurement Commission, the Ethnic Relations Commission, which are really important. And we have these things on paper, which look nice, I suppose, if you want to address your international development partners, but they don't function, so they practically don't exist.
But isn't there some obligation? The Constitution keeps saying there shall be.
But
and persons are sworn to uphold the Constitution.
Absolutely. So, for example, on the issue of the Integrity Commission, the Procurement Commission, those things should have come into existence a long time ago. I'll go back to the Procurement Commission because there's a very interesting dynamic that is often overlooked. Now, I understand that the executive was not pleased with the introduction of the provision. I think it's in section 54 at the end, which removes the no objection after a certain period of time. But that provision was introduced almost 10 years ago, and if it was the government's intention to operationalize the Procurement Commission, subject to the removal of that provision, it's not really clear why it took until 2012 for the government to raise its hand and said, well, look, we passed this, but on reflection, we don't think it's going to work. It doesn't meet our objectives. We would like to remove it and go ahead to operationalize the Procurement Commission.
So the distinction you're making is that there was a point in time up to 2011 when the government could have made that change if it truly wanted to bring about the Procurement Commission. Is that the point you're making?
At least 5 or 6 years. An enormous window within which that could have been achieved if it was the government's intention to operationalize the Procurement Commission.
Ronald, you mentioned both rule of law and constitutional democracy, and we sort of conflated them. How well have they functioned? You mentioned some exceptions, some difficulties. How does that affect development? How does that affect the whole legal structure, framework, culture, behavior of our society?
It's a difficult question to answer because there is no one route to development. I teach a course at the university on law and development, and what you see is that in different countries, different things work. And so, in fact, law and development theorists are coming to accept the idea that there isn't really a package that you can impose on any particular set of circumstances that will work. You really have to examine the nature of the society and see what will work best in this society.
But it's already there in the Constitution, so there's not a question of looking to see what works. You have to follow the Constitution, isn't it?
Well, I mean, obviously I don't have the resources or the experience to say definitively that if we follow the Constitution that we would have better development outcomes. I think that our development outcomes depend on persons of goodwill doing the right thing in the best interest of the country at a particular point in time. So, for example, if as a nation we identify that our development strategy depends on education or agriculture or tourism, that it needs to be well thought out, well planned, identify what the international best practices are, where our area of opportunity lies, and go forth with it. I'll give you an example, and making it to illustrate why this slavish idea of following the Constitution is neither necessary nor will give you the outcomes you want. We've decided that it would be in our best interest in the capital city to have a 5-star hotel, which is nice. I suppose people who entertain overseas visitors at the government level would like the idea of having a hotel as good as one they find elsewhere. But as far as a tourism package goes, I'm not sure that there's any serious effort at creating an environment that makes sense for tourism. You have a filthy city. So one would have thought that if you were serious about developing a model for tourism, that you would need a city that was clean, you would need a hospitable environment, you would need safe areas for tourists to enjoy. You need to identify what are these things that the tourists will come here to do.
Identify and provide.
Identify and provide. Now, no amount of constitutional reform will take you directly to a property situation.
But that's a governance issue, and that's normal governance and government issue.
I suppose so.
Let's talk, because you're president of the Bar Association, your relationship with the Attorney General.
Well, the Attorney General and I have been privately on friendly terms since I've known him. We've worked together in the past. I respect his ability, his legal ability. And privately, again, I would emphasize that we've gotten along well. And immediately preceding his difficulties last year, one would say happily that he was a friend of the bar, certainly compared to his immediate predecessor.
But the difficulties you're talking about, was that the matter on which the Bar Association actually called for his resignation?
Yes, and that call remains. I am not sure.
It's the first time the Bar Association has called for the resignation or removal of any Attorney General, is that correct?
I can't speak definitively on the issue, but I think you'd be hard pressed to find an environment where the bar and the Attorney General remained on the best of terms throughout the course. Of necessity, we will be on the opposite side of many issues, and it has often gotten acrimonious. I can't speak for too far back in the past, but I know that the current Attorney General's predecessor actually refused to speak to the bar unless we apologized for a letter that Mr. Rockcliffe had written about the state of the registry. Quite bizarre. I mean, like most things associated with that gentleman.
And you're speaking of Mr. Charles Ramsden?
Yes. So, in relation to answer your question, I mean, the Attorney General remains the Attorney General, and there are legal issues that he remains in control of. Nothing has arisen, obviously, in the interregnum on which we've had to engage him directly. But I don't think that one can say that it has ended. The Attorney General's manifested conduct that made it difficult at the time for him to continue. And the passage of time has not really cured that. In fact, the difficulties that former Minister Ramsran has gotten himself into, they've actually highlighted the fact that you have other members of government who behaved atrociously and who have not been sanctioned.
And you'd include the Attorney General?
Not only the Attorney General. I mean, the President's remarks, I think it was at Ishalton, where he is reported to have told the young man that if former President Jack Day was there, he would slap him and that he was stupid. And that the young man, in fact, was later assaulted by members of the Presidential Guard. If you were to apply the standard that the government has applied to Minister Ramsran, I think it would be difficult to see how either the President or the Attorney General could continue to hold the office that they do.
We're into elections within another couple of weeks.
Yes.
Less than 2 weeks, in fact. The tone and vision of this campaign, does it inspire any confidence in you that things are getting better?
I think one would have to be in a position to compare to previous campaigns, and both the aftermath and the lead up to other elections have clearly been much worse. Elections have been much worse in other places in the Caribbean. I mean, Jamaica 1980s, the mother of all violent elections. I think the Guyanese public has matured to a point where we have some confidence in the democratic process, meaning the outcome of the elections. I'm confident that the outcome of the elections will be received peacefully by all parties. I hope so. I'm pleased that there's been no credible reports of violence so far. I think there was a report of a minor skirmish. There have been reports of persons interfering with other persons, billboards, and that sort of thing, which in the grand scheme are fairly petty. It shouldn't happen, but they're fairly petty. The rhetoric on the platforms, I think particularly from the government, has been unacceptable. It's something that we've been concerned about for, I think, the past year and a half. There was an article in the Chronicle around that time which was exceptionally racist. No bones about it, which I found offensive. Much to my surprise, there were colleagues at the bar who found it difficult to join me in a complaint to the President. In fact, there were some who said absolutely, of course, without seeing it, accepting my representations of what it said. There were some who promised to read it and faithfully return and let me know whether they could support it. I never heard from them again. So I think it's obvious that our ethnic differences have not really advanced or matured to the point where we can say that people are prepared to deal with issues. I think, unfortunately, the government recognizes this, is prepared to exploit it for as much as it can.
With some of those things, just two final questions, would some of those things that are being said go over the other side of the law?
I know that you've given it careful consideration, Chris. I've given it some thought. I think aspects of it are. You see, the Racial Hostility Act actually seems to refer to things in print, and it's not really clear that a speech at a rally, which otherwise would have met the definition of racial hostility, would fall within that. The language has been insightful.
But then you have the Representation of the People's Act, which also has racial and ethnic issues.
I don't know, Chris. I wouldn't want to offer a formal opinion on the matter but I think without doubt one can say that the type of language being used in the political campaign is completely unacceptable. It sort of scorched earth approach has no place in the 21st century, and given our history, it is irresponsible for any politician to be campaigning in that manner at any time, any place.
Let me ask you one final question. I'm not going to ask you what outcome necessarily you want from the elections. What would you like to see the next government, whoever wins it, what must they do to fix the legal system?
Well, I'm glad you asked that, Chris. There are a few things that we're doing right now. The Chancellor has a program for the institution of new rules. Unfortunately, there have been some delays in the implementation of the process. I think the Chancellor would agree that those delays have reached a stage where they're unacceptable. But I do know that he has active plans. I can't tell you the precise timetable because the Chancellor hasn't shared that with me. But I know that as we speak, there are judges in Trinidad who are learning from the system that they operate. I know that part of the difficulty is the complement of judges. This has been increased to accommodate more judges. You need a lot of technology. There is an effort on the part of the Honorable Attorney General to introduce a system of court recording. Sadly, it seems to have gotten lost. The last we heard of it was there was an advertisement published in the paper which the Office of Registrar said that the Attorney General had no authority to publish, and a very unseemly skirmish between them. Again, there's delay. There's no court that is recording it. It makes absolutely no sense in the 21st century that the judge spends 2/3 of his or her time, during the course of a trial, writing down what people say. The technology is widely available and has been available for too long for us not to adopt it. We need to get to the stage in the legal system where we adopt systems and structures that are more business-like. The new rules introduces this through a system of case management where the court takes control of the pace of litigation. We've been talking about these rules for more than 10 years. It has not happened. It must happen. I know there's commitment in principle, but in the execution of it, it's slow. When these things happen, the government will say, well, we don't control the court. The courts are independent. And that is true, and it should remain so. But there is certainly room for the government to make clear what its policy preferences are.
Mr. Burch-Smith, thank you very much for appearing on Plain Talk, and I think we all wish to have peaceful elections and post-elections, a very functioning judicial system.
I'm sure we will.
Thank you, sir, and good night.
Thank you, Chris.
Viewers, we'll now take a very short break whilst my next guest comes out.